I just, because we're recording this, I'd just like to ask everybody to keep the sound to the to a minimum if possible. If you could remember to put your cell phones on mute, that would be great. The microphone that we're using is very sensitive, so it's going to pick up everything. So,
take her away, Maria.
So we have a slide here that just explains. Go to the next slide.
Yeah.
Easier said than done.
Well,
in any event, we're just reminding you that this is not legal advice. If you have a specific problem, please do get advice, and no solicitor-client relationship is created hereby. The legalese. During the presentation, we're happy to take questions from you. We may be answering the question a little later on in the presentation, so if you're not sure, we'll be here afterwards to answer more questions. We'll be taking questions from people present here first, and then for those who are on the webinar, please type in your questions. If we're able to get to them at the end, we will do that. And otherwise, please send us an email, and that goes for everybody. We will promise to get back to you with a response. We'll be available. The presentation should last until about 9 o'clock, and will be available till 9:30 to answer further questions if you'd like. So, on to the heart of the presentation. We're talking today about the transition or succession plan for the family-owned business. Lots of other assets, family-owned assets that we could talk about and spend entire days discussing. Family cottage, for example. But this is about the family business, which would typically consist of shares in a closely held or privately owned company. We're going to be talking about some of the tools that are available to make that transition smoother. And as advisors to the business owner, our job is to ensure that the founder's wishes, as much as possible, are going to be carried out in the future. In addition, we're going to look at some strategies for making sure that the wealth is preserved and taxes are minimized. Whether those are capital gains taxes or probate fees, etc.
Just scroll through the outline.
Next slide. Yeah. We're going to be looking at what dynamics are at play within the family. We're going to be talking about whether a will is adequate, if there's one in place, and often there isn't. Whether a will by itself is going to do the job. Whether perhaps trusts might be of use. They're a powerful tool that is quite underutilized and also, unfortunately, not well understood. We're going to also touch on some new problems that the Family Law Act, which came into force about 6 months ago, has created a bit of an issue for discretionary trusts. So we'll be taking a look at that. And then Bill is going to talk about tax and legal issues, identifying various options for the transition. He's going to be looking at the actual transactions that may be available to the business owner, and other strategies.
Just a second here, Maria.
Oh, sorry. Uh-oh.
It's just not wanting to cooperate right at the moment.
Special effects today?
Yeah, disco.
You had it there a second ago.
Okay.
Right.
Not working properly, but let's just bear with it. Maybe the battery's going or something, but anyway, let's try. Yeah, exactly.
So, and then Bill may finish off with shareholders agreements and some miscellaneous tax issues and strategies if time permits.
That was some miscellaneous stuff.
Yes. Okay.
Before you get going, Maria, you should probably just say you've been doing this for a little while.
Yes, I've been practicing in this area for getting close to 30 years, and Bill, I think you're...
Yeah, I've been doing this for about 30 years as well. I've worked from small business companies to the largest law firm in the country back in Toronto, so we sort of seen it and done it all. But Vancouver is basically a place of entrepreneurial businesses, owner-managers, and whether it's a $500,000 company or a $20 million company, most of them are, the business structure tends to be the person you're dealing with, the money's coming out of their back pocket. So I think we all know as financial professionals and clients, the owner-manager sort of drives everything, and that's what we're trying to deal with today. We both have got a lot of experience dealing with this. And a lot of the issues are beyond the state issues. We've got some new legislation that's coming up, which Maria's going to cover, which is important. And of course, there's all kinds of tax strategies, but a lot of times it's just dealing with the families and getting them to make those decisions. I think many professionals who deal with this on a regular basis know the difficulty. And one of the reasons we're doing this is now we're not going to be able to get too technical, but we want to sort of, there it goes again, hit it at 10,000 feet. And what we'd like to be able to do is just sort of address the issues that we think you should be talking to your clients about, or if you are a taxpayer, the things you should be thinking about. My experience is people get into our offices sort of well after the fact when they really should. And I know it's a difficult thing because people don't want to address these issues, but that's what Maria and I are going to try and encourage you to do. Here are the issues, here are some solutions. Let's talk to our clients. I mean, it's good for business, but it's also good for the clients who aren't dealing with this stuff. So.
And you as accountants, financial advisors to your clients, you're often closer to the family and the individuals themselves than we are. We, as Bill says, we often get involved a little further down the road. So you have a unique opportunity there to be able to sit down and discuss the issues with the client and maybe say, well, maybe we should have a look at your will. Maybe we should talk about where this is going, and we'll get into some of those things, some of the ways that you might be able to approach that.
Should we move on?
I think we're on to the next slide. So as a starting point, I think it's important to know what it is that the business owner or the founder has in mind. What is his or her vision for where this is going to go once they're out of the picture? And how can we help them to create that vision to make sure that it actually happens? So some of the options that are obviously available is a transition to family, and that's basically where we're going to focus to start with today. I think Bill is going to talk about some of the other options by employees, an arm's length sale of the business, and possible liquidation of the business, in which case it's more of a transition of money rather than the actual operating entity. So, as I mentioned earlier, it's a really good idea if you have an opportunity to review your client's will. I see people with substantial businesses come in asking to have their will reviewed. You look at it, and it was often made many years ago when their children, somebody told them they needed a will because their children were little. And so, these things are 20 years out of date. Doesn't even mention the business often. There's somebody who's completely inappropriate named as the executor who wouldn't be able to deal with the business at all if it came to that. And it just really doesn't work. So there's an opportunity there to help them put something in place that's going to be able to help that business transition wherever it's going to go. I recommend that you do a family tree for the family. Know who's in this picture. Go back a generation if that's appropriate. Some of these businesses have come down from the person's parents. There is a portion of it that's come down. And there may be other, uncles and cousins and things that are kind of lurking in the background that we need to know about in order to structure things properly, because those people can sometimes put pressures on that succession plan. Within the family, identify who has the specific talents and interests and who has the needs or issues. You're going to get the children or the one person who's really keen on moving the business forward, and then you may have some people who are to their dividend checks. You really want to set up a situation where one or two family members are doing all the heavy lifting, and the others are kind of like the shareholders expecting their dividend checks and making helpful suggestions for the people who are actually doing the hard work. That's a recipe for disaster down the road, and if that can be avoided, so much the better. Does that will work given the present circumstances? Bill, can we
Yep.
slide?
Let's see what we can find now.
Another important question is the family situation stable? Is the founder's marriage stable? What about the potential inheritors? What kind of relationships are they in? What kind of issues might they have? Is the son, for example, who's going to be taking over the business in a shaky marriage? Or are there in-laws there who might create problems? You'd be surprised how often the problems in an estate situation are actually not the family themselves, but the people circling around them, the in-laws and other people. Spending habits are an indication of potential issues. Addictions are something that can really put a business off the rails, whether it be drug addiction or things like gambling, or even an addiction to traveling a lot. Is the person that you're thinking is going to be the taking over the business really interested in being around? I'm also going to touch on the potential use of multiple wills. I'll do that a couple slides further down.
So one thing I just wanted to say, Maria, is on wills themselves, I mean, as whether you're a financial professional, accountant, whatever, I recommend try and get a hold of the client's will. I mean, we get clients, I'm so embarrassed, we're doing a reorg for them, an estate plan, and then it kind of comes up, well, the will hasn't been looked at. Well, generally, of course, as a lawyer, I'm going to ask to see your will, shareholders agreement. I want to see it all if we're doing estate revision, but I recommend that, you don't have to be a lawyer to read a will, and in a lot of cases, people think the business is going to little Johnny or something, and when you read the will, none of this works. And, as financial professionals, I think most of you can spot this easily, and it's just amazing, as Maria said, how often these wills are just so terribly out of date, probably done because they had young kids and we needed a guardian. I mean, I think most of you have seen the situation, but I just encourage you to do it because, clients sometimes don't want to let these things go, but they know they need help.
Right.
They all know they need help.
And I'm not going to get into the specifics of wills, but a well-drafted will can really go a long way to putting a plan in place. It gives the owner an opportunity to choose who's going to look after things after their demise. Who is that executor going to be? If you don't put that person in place, it's either somebody who's not really capable of taking it on, or there's no will at all. Somebody has to go to court and be appointed. That can result in the wrong people being in charge. A will is really a way of allowing the business owner to take charge while they are able to do so, and while the business is viable. And
let's move it on to the next one.
oh, sorry. On to the next slide. So, as most of you probably know, there's a new act coming into force at the end of March. It's the Wills, Estates, and Succession Act. The title at the top is incorrect, but we call it WESA. It's going to make some changes to terminology, nothing serious. Instead of testator, we're going to have the will maker. There is unfortunately no change to will's variation. It's been rolled into the new act in its entirety, so we're kind of stuck with that. There is also, Section 58 allows a court to fix a near will and to turn it into a will. So be really careful in, if people are wanting to write you letters about what they want to do when they die, be really careful about that, because not that the courts, I think, are going to actually take those sorts of things and turn them into wills, but what will happen is people who have a document like that, Aunt Mabel sending an email saying, I'm going to give you the house when I die, they're going to go to court because Aunt Mabel meant this, and that this was supposed to be the will. So that's where the danger lies. I think we're going to see more litigation. There's very little that impacts existing wills, but there's a big change if there is no will. So currently, we have a situation where, still not working well?
That's annoying.
Currently, if there is no will, the law says that the spouse gets the first $65,000 of the estate, and then the rest is split between the spouse and the children. And it doesn't matter whether the children were the children of both the spouse, the surviving spouse, and the deceased, or whether they were only children of the deceased. Under the new law, that changes. Also, the spouse currently gets a life interest in the family home. So under the new act, there's a major change to that. The preferential portions of the estate increase significantly for the spouse. If the surviving children are the children of both the deceased and the surviving spouse, that spouse gets the first $300,000. That drops to $150,000 if the children are not also the children of that spouse. And there's an error here. It says the kids get all the rest equally. That's not correct. The kids get 50% of what's left, and the spouse gets the other 50%. Just make that change in your slides, please. Let's be fixing that before this gets posted. Interesting thing to note, there is no longer a life interest to the spouse in the family home. So if that spouse wants the home, they're going to have to buy it out of the estate. They're going to probably want their preferential share in order to do that. And what could happen is that the liquidity to make that purchase might be in the family business. So you could find pressure on the estate to sell the business so that the spouse can have his or her preferential share to be able to stay in the home. So it makes it all the more important these days to have a will in place. I mentioned multiple wills a little earlier. Multiple wills can give you the option of separating the probatable, and I'm not sure that that's a word, but I'll use it anyway, the probatable assets from the non-probatable assets. Assets that have to go through probate, like real estate, bank accounts, those sorts of things, can be placed into one will with an appropriate executor to look after those things. Could be a family member, could be the spouse. And then the non-probatable assets, which fortunately will include shares of a privately held company, can be placed into a separate will with an appropriate executor, a business partner, the child who's going to inherit, for example. You can also use multiple wills to deal with assets in different jurisdictions. So the will for the Canadian assets, the will for the Hong Kong assets, for example, something we commonly see. Separate out the U.S.-based assets. As I mentioned, you can appoint different executors. These are tricky to draft. It's very easy to step offside. You end up revoking one will by making the next will. You know, all kinds of weird things can happen if they're not carefully drafted. So please do ensure that you get a professional who's done these things to make sure that you're not creating problems.
And this is becoming more of an issue these days with all of our clients moving to Arizona or Palm Springs, as we're seeing. Of course, the problems there are even more compounded because of the U.S. issues. But again, it's a good tool to think about using if you get it right. And you got to, as Maria says, you got to be very careful if you're drafting multiple wills.
That's right. So I'd like to just turn to the succession plan itself. I think these questions we've already dealt with. How do you make sure that the child who's active in the business is able to run the business? Children who are not active are fairly compensated. And what does that even mean? In a will variation situation, it basically means equal, which may not be what's appropriate for the family. Special talents, unreasonable expectations, and how do you take care of these strengths and talents? How do you use them? One way of dealing with those questions is to use trust. They're a great tool. They can be used to avoid will variation. They can be used to deal with potential matrimonial disputes, future matrimonial disputes. You don't want to be setting up a trust in the middle of a matrimonial dispute. You're going to be in trouble. Trusts are very useful in these contexts. For one thing, they're a private document. Unlike a will that goes for probate, nobody other than the people involved, the trustees, the advisors, need to know what's in that trust.
That's a big one. I'm surprised. I mean, we've got wealthy clients. The client in here the other day, $30 million in assets, and I said, well, you know, you realize all the stuff in your will is now going to be known to the whole world potentially. I mean, it's on the public registry.
Yeah.
What do you mean?
Especially when there's the $1,000 gifts to the 16 grandchildren who all get a copy.
That's an additional problem where people want to leave all these amounts. That another client also had $30 million, and he was leaving $1,000 gifts to people when he had all this pot of money. And of course, then they had to. If I didn't do the will, we didn't do the will. Never would have allowed it out of my office. I would have refused to do it. And now there's 30 people in a small community who all know about the will, and of course you can just imagine how that was spread around town. Everybody knew about it. So, you know, in that case, we'd actually gone to some effort to grab some of the shareholdings and put them into an alter ego trust, which we're going to discuss in a bit here. But, I mean, so that removes you from the public realm of the Supreme Court registry and the probate registry, but it doesn't help you when it comes to all the gifts and bequests in the will.
Right. The other thing about trusts, of course, is that they do not go through probate. So you get the privacy benefit, but you also aren't paying probate fees on those assets. Probate in British Columbia costs 1.4% of the value of the estate over $50,000. So it can be a significant amount of money. And as I mentioned earlier, a trust cannot be attacked under will variation. Come on to the next slide. Yeah. So trust can be created in a will, of course, but that doesn't solve those other problems. So what we like to use are what are called inter vivos trusts. Inter vivos just means during life. So it's the trust that you set up during your lifetime. They are often part of a corporate planning strategy, family trusts, and I think Bill is going to talk about those. Joint spousal or alter trust, or something created under the Income Tax Act for people who are 65 and older, and provided you follow the rules, it gives you a rollover into that trust, which means there's no tax payable at the time that the trust is created. The assets sit in that trust for the life of, if it's an alter ego trust, the life of the person whose alter ego that trust is, and for joint spousal trust, for the life of the last to die of the two spouses. If you stay outside the rules, it gives you a nice long tax deferral, potentially, and then at the end of the day, the assets roll out to the beneficiaries, the ultimate beneficiaries that are named.
There was a case here in BC, Mordo was the name of the case, and Justice Wedge wrote what I consider a brilliant judgment. It's like a book. And basically it was a fairly wealthy family. The son was a bit of a knothead, and went after the daughter who had looked after the aging parents most of the remaining years of their life. And he tried, and they left, he was a multimillionaire, and they left virtually all the estate to the daughter who had been giving care. And the son hired Donovan Waters and every other known expert in town to go after this. And Justice Wedge wrote an 80-page decision. But the point that I want to get to, because there's always a lot of questions as to whether a gift under a joint spousal trust or an alter ego trust could be attacked as being a testamentary disposition and therefore subject to wills variation. And in that decision of the BC courts, it was made very clear that if it's done right, it works. So it's something to really take into account, because when there's money in families, we all know it, you've got trouble. And particularly if it doesn't get divided up evenly. And even the idea of what evenly is, you know, it's just amazing what can happen with people and money.
Evenly may not be 50-50. It really depends on the circumstances. Really brilliant area where joint spousal trusts or alter ego trusts can work is in the situation of second marriages, where you have a spouse who is not the parent of the adult children. And it just makes sense for there to be a life interest for that spouse. You know, often there's somebody who the founder met through the business, so they're also involved in the business. But the adult children can't wait to get their hands on things. And so after the demise of the founder, who's kind of the glue who held everything together, there can be huge fights if it's done through a will. So this is where these trusts, which as Bill has pointed out, the courts are happy to uphold. They're a powerful tool in that case.
So a spousal trust under a will can look an awful lot like a joint spousal trust, the difference being the ability to attack them. And as Maria pointed out, we have a new statute, Wills and Estate Succession Act, but the wills variation rules have not changed. So we've still got that problem. And let's face it, the courts have been willing to dabble in the states. They just can't seem to help themselves. So it's just, you know, a good point to keep in mind.
And that's a good segue into the last bit that I'd like to talk about, which is family law agreements. We have an issue that's been created under the new Family Law Act regarding discretionary trusts. Family law agreements can be used to create additional certainty. They should probably be a prerequisite to share ownership in an estate freeze or a reorganization type of situation. They can be built right into the family trust to define that a beneficiary who does not have a family law agreement is not going to be a beneficiary until they do get one. If we can go to the next slide, Bill, I'll talk about this problem that's being created by the Family Law Act. It's a bit of a complex situation. But what that act does is it says that everything is a family asset and therefore open for division unless it is exempt property. It goes on to say that a property in a family trust is in fact exempt property, except, and it's this exception that creates the problem, the growth of that property, so not the property itself, but the growth in value that's in that trust, is considered family property.
So dad is got adult children. So dad settles a trust. We've all seen these. Settles a trust. They got 3 or 4 kids. The kids are all beneficiaries. The kids are now adults. They're in their 40s. A couple of them are married. And this is the bizarre thing, because the family bar who wrote this new legislation, the Family Law Act, I guess they went to court and they were fed up with hearing the fact that an interest in a discretionary trust is worth nothing until the trustees exercise the discretion. So they couldn't get at the value. So the family bar came up with this, I'm sorry, but just brilliant piece of legislation that says, well, we don't care that that asset in the trust never belonged to the son or the daughter or whoever the family member is. We're going to exempt that property. So the shares of the family operating company, they're sitting in the trust, settled by dad, who's got a 40-year-old son who's in the middle of a divorce. Under the new rules, basically, the courts, the legislation says that the shares in that trust are exempt.
That's right.
But the growth in the value of those shares from the time of the marriage and the time the trust owned the property to the date of the breakup is subject to a claim.
That's right.
Which, if you think about it, it's bizarre, because where's the money to pay for it? But there's an additional section in the Act that says in certain circumstances, the judges even have the ability to go in and reach and seize that property.
So think about this. There's the son who's in the middle of the divorce has 3 other siblings who are also beneficiaries. Nobody gets anything unless dad, who is the trustee, and it's a discretionary trust, says, okay, there's going to be a distribution. So under the Family Law Act, it's that entire value that's subject to seizure by that one son's spouse. The other beneficiaries are not going to be very happy about that.
So each one of the potential kids here, let's say there's 4 kids, each of them has a half a claim on that increase in value.
To that full value. It's not going to work. The problem is that the family bar, family lawyers, and unfortunately many judges don't really understand trusts all that well. So we'll see where it goes.
I think what they understood was they're having a problem bringing claims against discretionary interest in family trusts. So they fixed their problem, they think, but who knows what a judge is going to do with this. But this would apply to every inter vivos trust that's out there. So that issue now, and the other problem is, of course, we now have a definition. If you've been living together, common law, for 24 months, we now have a property regime. So I think most of you heard about this, but nobody has any real answers, although we've got a few suggestions.
We'll see how well they work. Ultimately, either the legislation is going to have to change. There seems to be less than enthusiastic support for doing that. It could easily be seen as the government sort of helping the wealthy to the exclusion of everybody else. Same kind of argument that's being made about income splitting right now. But if we could go to the next slide. There's a few suggestions been made. Use a corporation instead of a trust, but then you have the shares going into a will, and
you lose all kinds of too much flexibility lost.
You lose a lot of flexibility there, and also protection. Using stacked trusts is probably one of the more viable solutions. It might actually even work with existing trusts, where you can add another trust.
The whole idea would be to put the children, the adult children, in a trust, the only asset of which is a discretionary interest in the real trust. So the real trust, so you'd have to refreeze if you had an existing situation. If you're setting up a new one, you'd set up sort of one trust with the common shares of the company, and the beneficiary of that trust would be the second trust and maybe mom and dad. And then the second trust basically would have an interest. We're back to the same argument, which is what's the value of that thing that trust holds it's a discretionary interest in the trust. It's nominal.
But there's not going to be any growth in the value of that either.
But you've got the ability to roll out the shares of real trust into top-tier trust down the road on a tax-deferred basis to implement the estate plan after you get past the years when you've got these problems. So, I mean, and the commentary, I mean, Dave Thompson speaks on this a lot from Thorson's. I mean, he suggested this. We looked at this when it first came out. The question is, what's a family court going to do with this? You always worry. I mean, I've been in court and had my butt kicked through the courtroom door pretty hard when I thought I had a great technical argument. So you do worry about that. Yeah. The simple solution is to insist on having. You can have a family law agreement that just simply deals with the shares of that company. You don't have to deal with all the assets. You can just simply have an agreement that deals with the one asset. But again, that's a kind of a toxic thing to raise.
Yeah.
Hey, honey, do you mind signing this agreement?
Yeah. Well,
it's going to cut you out of the family wealth.
Hey, honey, Dad isn't giving me any shares unless you sign them. So the family law agreement, you can also define beneficiaries within the trust as we work going forward. Not necessarily going to be able to go backwards and redefine beneficiaries in existing trusts. So that one's probably not going to work there. So those are my comments. So I'll turn it over to Bill at this one.
Okay. There's a number of slides here that in my presentation that Maria's already covered, but just out of completeness, what I wanted to do is sort of get you thinking about it. If you are a taxpayer, a business person who's got these issues, or you're a financial advisor, and encourage people to sit down with their clients and get them thinking about this stuff, because we oftentimes, and we see a lot of this stuff come in, oftentimes it's sort of well down the road when we could have done other things if we had an opportunity, but it's just kind of too late. So I think there's sort of four basic situations. I mean, you can do an estate freeze on a company, the company that's sort of just run its course. Dad or mom, whoever's been running the business, is no longer sort of interested in doing anything. They're losing market share. Basically, they got a nice pot. Maybe they bought an office building they've operated out of. They've got some investments. The trick here with the business wind-up transition is to try and catch the company when it's still on side of the capital gains exemption, the Qualified Small Business Corporation share rule. So the problem is by the time they get in my office, it's way too late. So the financial people are the ones that see it. And there is planning that can be done for these companies, even though they're not going anywhere. The next obvious sort of transition option is family. And, I sat down with a client not too long ago, and he said, I got 2 kids. I don't think any of them are necessarily going to be able to run the business, to be honest with you. Okay, well then, so what's your other option? I mean, you've got a good business here, good cash flow, good customer list. Well, maybe an employee buyout, or maybe an arm's length sale. Now, what we tend to find is a lot of people have inflated views of their companies in terms of arm's length sale. I mean, I had a guy that came in, so this is back when there's 750 exemptions, so husband and wife own the company. He's selling a product here on the coast. He is the person. He's the only guy that does this particular product. It's brilliantly designed. He's great. He's 72. So, Joe, okay, well, you're going to sell the business. Yeah, well, I'm going to at least $1.5 million, maybe $2 million. We'll get 2 750s. I'll pay no tax. Okay, but who's got the relationship with all the customers? Well, I do. Okay, well, who's designing this? Because it was a very technical product. Well, who's designing this product? Well, I do. So who are you going to sell the business to? Because they're going to want you to stay working for another 10 years. Oh, no, I don't want to work. So, I mean, again, it's a question of getting, I've seen successful businesses, but nobody has got to them in time. And, I know we've got a bunch of accountants listening online. There's probably a few in the room here. And what happens is everybody gets busy. So it comes to tax season. I don't know, as soon as January comes around the corner, everybody's hitting the deck hard. and nobody, you're looking at it, you can see the buildup in the assets in the company, you can see what's going on, but nobody has really sat down with the principal and said, you've got a good guy there, you need to turn him into a key employee, you need to make this business so that you can walk away from it and it'll run itself. And it's amazing how many successful business people just simply don't see that. So I think those are the options. I had a situation here recently where a guy come in, he's got a service business in the electrical industry, and he's got construction business. Well, I think most people who know business understand that construction goes from job to job. He's got a good reputation. They do big projects, high rises. They're making good money. But I said, that business is not saleable. Who's going to buy it? Because it's only as good as the last contract. He says, yes. But he said, I got 2 key guys here that I'm bringing on, and I'm going to let them in for a deal. Okay, now you're thinking. So those are the options. And as I say, too often I don't think anybody really talks about it or thinks about it. So what are the sort of traits? A business wind-up, typically we've got a business that's, whatever the product is, it's becoming obsolete. They're losing market share. And, I had a situation where a guy was in the log trading business, and one day he just got tired, and he stopped doing it. Now he's got a couple of $1 million that he was using in the business to permit him to do the trades. Nobody paid attention. The accountant, financial planners never said anything to him. 2 years later, he dies, or 3. It was probably 3 or 4 years because it was outside of the 2-year period for the exemption. And so what we got is a company that stopped active business about 3 years ago. He's got $2 million in the bank, no capital gains exemption. And of course, the family thought they had $1.5 million coverage. So all I'm suggesting here is if you've got a client like that, do the crystallization. So basically convert the common shares into preferred shares and build up the ACB. If nothing else, it costs a few bucks, but you bought a life insurance policy. So, in a lot of cases, people think, well, there's nothing I can do. I don't have an active business. I'm going to retire. There's no one to sell it to. I'm just suggesting that there's some tax planning you can do and, get it in effect while you can still do it. And in some cases, we've got a significant real estate asset that will lose its status as soon as he stops to operate. But while the business is still running, the value of the business may be driven entirely by the real estate. Crystallize and get those exemptions. It's like getting a one-time purchase price of a life insurance policy. The family transition, Maria's already kind of mentioned this, but obviously, is there actually somebody there that can run the business? And I've had to have some heart-to-heart discussions with clients where, okay, well, I got to put little Johnny in charge of the business, and then you sit down and you start talking about Johnny's skill set, and you realize, this is going to be bad. And what's worse is the client wants to put the 3 other kids in the ownership position on an estate freeze. Well, that's not going to work. Because number one, people are driven by self-interest and greed. And so we've got 1 kid working for the 3 other daughters. I've had a couple of situations like that. There were 3 daughters and 1 son. Whatever it is, it could be. I had another client, it was the daughter, and there were 3 other kids, a printing business. And as if you put these other 3 kids, or however many kids there are, on top of the shoulders of the ones doing all the work, there'd be a lot of resentment. The business probably won't succeed as well. And so you really need to sit down and talk to them about that situation. Of course, the other thing is, what's going on with marriages. That can be a real disruptive force. And just general competition between siblings if you put them all into the same ownership position. So you need to sit down and figure out what works. Sometimes it's better just to sell the business. The other problem is, I had a client that came in 2004, and they have 3 sons, and they're just all squabbling. And Dad, his attitude was, you know what, I'm just going to leave them to deal with it. So here we got a $10 million business, and he's just going to leave them to deal with it. Well, they can't get along when Dad's in the room. You can imagine what's going to happen when he's gone. So, and then the problem becomes, once Dad and Mom are gone, because Mom, and she'll probably outlive Dad typically, she's not going to want to deal with any of this. They're both gone, and now we got 3 deemed arm's length persons trying to sort out a mess. It's not going to happen. So a little tough love with clients. You just sit them down and say, you have to make a decision on this. And if it means picking one over the other, you've got other assets. I don't care if it's not an equal division. If you don't do this, the legal bills and sorting this mess out is going to be brutal, and it's just going to be not good for anybody in the family. So try and identify those situations. We had a client recently where the son that was involved in the business, daughter had no business interest at all, but Dad wanted to do the right thing. So what we decided is we spun off all the investment assets, made that pot into a separate company, made that pot roughly equal to what the operating business was, and we're doing it now. Dad controls everything. It's all related parties. So the opportunities are now while Mom and Dad are still alive, particularly whether it's Mom or Dad running the business. Whoever the person is that's running the business, get them to make those tough decisions or leave a mess for your kids. So clearly one of the big issues with family businesses is getting, if you've got passive investments. I had a client who had a Harley dealership of all things. These guys come into my office. They're in their 60s. They're still riding their Harleys. They love the business. The whole family's working in the business. They obviously love it. They bought a piece of property at a corner of 2 major intersections. The property itself is worth way more than the business, although apparently selling Harleys is a lot more lucrative these days. So they basically said, we just want to go on riding trips on our bikes, and we want to go to Hawaii. And, we want our kids to continue working in the business. I said, here's the deal. Spin out the real estate into a separate company, sever the ties. If the kids run the business into the ground, so be it. Kick them out of the place and lease out the property. And that's what we did. And I think that it actually worked out fine. But again, it's catching these in time. Employee transitions. This is a difficult area for sure. But where there's no clear successor, you can help your clients by simply saying, hey, identify those key employees and get them tied up in some kind of agreement, whether it's an employee stock option plan or a stock appreciation rights plan. When employees hear about this, they're not always terribly happy about it because, we actually had a client where, it was a great offer by the owner of the business, and his senior guy went home, talked to his wife, and his wife said, well, you're not going to get any stock in the company. So he came back and said, well, I have to have stock. So no. The lawyer's telling me we don't want any minority share positions, which was me. Try and stay away from that. But, of course, the problem is those kind of plans don't necessarily get you to the capital gains exemption. So that becomes a real thorny issue. So, what we've recommended with clients is, if you're going to do something where you're going to actually issue shares, you're going to need a shareholders agreement, and preferably get them into an agreement where the carrot is out there 5 to 10 years before you start bringing them into a share ownership position, because as soon as they own shares, you've got a really big problem on your hands. And, and I understand everybody wants to be an owner. They want to be in an equity position. But, so that's the challenge with employee transitions. Identifying those key employees, you got to do it early on. And avoid issuing minority share positions until the end, until you've at least got a shareholders agreement. And then the arm's length sale, well, the typical problem you see here is clients think their business is worth way more than it is, and the truth of the matter is when they go away to Hawaii, they're on the phone with the business every day. That's not a business that runs itself. It really can't be sold independently. Things you can do to help your client, though, obviously encourage them to bring along that key person or key persons, tie them up under contract, which is a good thing. I've seen situations, guy came into my office, we had it was a big sale at the end of the day, but you had 50 employees writing software code. The first 25 that had come in all signed contracts and assigned the rights to the code that they'd been writing. Then they got sloppy because they got good, and there was money coming in, they were successful. Suddenly we've got 25 employees who haven't signed any contracts, and we're staring at a deal for $20 million. And of course, the company on the other side, $8 billion company, sends McCarthy's from Toronto out here to Vancouver to negotiate the deal. Where are the contracts? Oops, we don't have any. So it just got a little more expensive at that point for the owner, because he then had to go to these guys cap in hand and say, look, I'll up the bonus, sign these contracts. So again, this is something where, as lawyers, we can't really do this. It's the financial advisors, the clients themselves, if they're listening, if they hear this, or it's the accountants who are dealing with this stuff. You're the guys that can do it. Check and make sure if they got an operating facility and a lease, make sure it works. I mean, any major contracts, you need to make sure they're in place. Does the business run itself without regular contact? I mean, that's clearly a big one. So a few of the legal issues, Maria's already talked about it, but, a will is a really great spot to start. A will is oftentimes, it's the game plan. And as Maria says, I mean, how many times have we seen it where somebody comes in, the will they've got was drafted because they're worried about guardians for their kids because they're going away on holidays and leaving the kids with grandma. Get those wills, read them. You don't need to be a lawyer to read them. I think I sense a great relief, when the clients finally, because we insist. I mean, I will not do an estate plan without looking at the will. And then there's embarrassment, and then it's like, oh, okay, that's great. It's good to have somebody look at it. Oftentimes, they work. It depends who's going to get the business. But if it's intention to get the business to one person and get them in control, and all you've got is common shares, it can be a disaster. Again, I mentioned this earlier. If you've got, potential siblings, successors, maybe everybody in the family is, entrepreneurial families tend to have entrepreneurial kids. So you need to think about how to break it up. But again, it's a rare situation where two business people can work together in a business and work together, literally work together. I mean, it just doesn't work that well. With family and egos and money, it seldom works. So better off to split the business into separate components if you can do it. Again, the time to do this is where mom and dad are still alive and controlling the businesses. We talked about alter ego joint spousal. And again, as Maria pointed out, this isn't just to avoid state duties. You can avoid rules variation claims. It's a good time to get the businesses separated out and to avoid discord down the road. Capital gains exemption. Again, we're flying here at 10,000 feet. Don't want to get into all the details, but it's now $800,000 a pop and indexed annually. That can be a significant thing. You want to, the crazy thing about the exemption, it was created in the mid-'80s as an incentive to spur on new business because the government realizes that most of the jobs in this country are created by small business. So, and you see, they just jacked it up another 800,000. People thought it was going to disappear, but basically, I think the government has realized that small business creates a lot of jobs in this country. So it's an incentive. The problem is, the other thing they do is they give you a low tax rate, so you've got money to invest in your business. The low tax rate, businesses mature, the excess money that's being generated no longer is being put back into hiring employees and inventory, and next thing you know, of course, the company's offside. So small business deduction designed to allow a company to prosper and grow also kills the capital gains exemption. I would say most businesses, by the time they get into my door, don't qualify for the exemption, although they're all sort of counting the money and on the big sale they're going to have, and et cetera, et cetera. So again, worthwhile taking a look. It's pretty easy to see when a company's building up excess cash. If it is, you need to do something. So options are purify and crystallize while it's still on site, spin off the redundant, non-essential investment assets, or do an estate freeze with a family trust and a holding company to get you there as well. So a couple of things about crystallizing, and I don't know, I'm not sure about the knowledge level here, but I think most people have heard of it. The way to do it without actually having a sale was to take your common shares, transfer them back to your own company, and take preferred shares and make a Section 85 election. That then allows you to elect at proceeds up to the amount of your available exemption, and lo and behold, so now you've got preferred shares which have an ACB equal to whatever value of the company. So if you've got two mom and dad and the business is worth $2 million, you can get $1.6 million in basis. So that's a way to grab the exemption now while it's still on side. The trick is with a business that's winding down, you got to get there before it becomes non-active. What we saw in the early 90s when these rules first came out, and everybody thought the exemption was going to go away, was people were rolling shares of their operating company into their holding company because a lot of people hadn't figured out how to roll shares of a company into itself. And the result there is that certainly I've seen a bunch of companies where the capital gains exemption is inside a holding company. So I'm in the classic example. I had a guy who wanted to sell his A&W franchise, worth a couple $1 million bucks, and he comes into my office 2 weeks before the close of the sale. My lawyer said maybe I need some tax advice. I look at this. When's the sale closing? 2 weeks from now. Okay. Well, you got a couple $1 million of assets in your holding company, and you got shares inside there with high bases. Nobody buys cash. Nobody buys investments. The purchaser wanted to buy the shares of the operating company. So, have a look. If you've got situations with clients that have been done years ago and they've got holding companies, if they roll those shares in and they've got high basis in the holding company, they just wasted their exemption. Now, in this case, we're very lucky because there was a huge amount of safe income or retained earnings. And the guy had basically not been drawing anything out of his company, so we were able to largely fix the problem. But the problem with that issue is you can't typically fix it unless you're several years ahead of any sale. So look for those situations. Again, capital gains exemptions, you got to watch out that you don't walk your client into a tax problem. Minimum tax is a nasty surprise. Ables and CNOs, most accountants know how to check for these things, but just to keep an idea. And in situations where there was really nothing going forward going to happen, it was going to be a wind-up, we've paid out bonuses or dividends to get the cash out of the company to get them on side. So I think I've mentioned the rest of that. The holdco spin-out, which is essentially taking your investment assets, maybe even your real estate assets, moving them into a holding company and severing the ties. There is some case law on fraudulent conveyances you got to watch out for, so you got to be careful about the debts and liabilities that are out there at the time. But these are things that, again, clients don't necessarily think of them. Financial people would be aware of them. You got to be looking at the financial statements. The whole idea behind the holding company is to then siphon off the excess cash on a regular basis to keep the operating company on side. State freezes, I'm sure most people have heard of this. You do a freeze, you issue common shares to the trust, and you put everybody in the family inside the trust, and now everybody's exemption is now available. So the only thing about this trick, and it works, is so you do a freeze, 4 or 5 years later, and we've had the situation, $20 million offer comes along for the company. So now the principal, he's looking for everybody he knows, aunts and uncles. He wants to put everybody in the trust. Okay, well, that's a bit of an issue. But he wants to also take the exemptions of all of his kids. So I think we're going to see some lawsuits here one of these days when these entrepreneurial kids grow up and realize that dad burned through their exemption, 20 years ago or 15 years ago or whatever. But that's a big issue, but certainly a lot of people have been multiplying the capital gains exemption by putting common shares into trusts. I think we're closing out on time here, but just cover a couple more things. Again, for people who work in the area, they're going to know what this is, but I have seen lots of situations where mom and dad have lots of personal assets. I mean, successful people, the pot just gets to a point where they just don't need any more money. And so the freeze has been done, and here's a couple of million, but they're still drawing money to live out of the company. So they're taking out, you know, having a good life in Arizona and flying around the world, and they're spending $500,000 a year. And, you know, if they, instead of just taking a salary out of the company, if they just started redeeming some of those preferred share, every dollar preferred share. Now you got to run the numbers on the difference between the dividend rates, which are now at 38, 39, versus what they're paying on the salary. So you need to run the numbers. But every dollar of share you buy back, you eliminate a dollar of capital gains. And we see this all the time. Well, gee, you've been drawing money out. You've got all these preferred shares. You've got so much wealth personally, you're never going to need these shares. Why don't you just buy them back? So just something to keep an eye on. You've got to run the numbers before you do something like that. The other thing I wanted to mention is for those of you clients with existing family trusts, or for those of you who are taxpayers out there who've had some tax planning done and you've got a family trust, you want to make sure that the operating company underneath it is onside the QSBC test. So you need to double check that. You need to know what the 21-year deemed disposition deadline is. We've had a number of trusts referred to us by major accounting firms in this office. My paralegal looked at it and said, oh, I think we got a problem. The 21 years was up 6 months ago. You know, like that just shouldn't happen. So it's sort of, yeah, the lawyers, we do all this work, then we throw it out the door. And the accountants sort of look at a T3 once a year, and they're just like, you know, I don't want to spend a lot of money on this because the client doesn't want to pay for it because it's just holding shares. And so nobody really pays attention. And the time ticklers are not set up. I don't know what people are doing, but of course we're seeing a lot more of these trusts now that are getting close to over the 21 years. So if you've got any situations, you know anybody that's got a family trust, check it out. Make sure that the trust qualifies for the rollout provisions. People do crazy things. You know, we were short of money, so I wrote a check for $5,000 so the trust has some money. Okay, well now you can't do anything with that trust. You can't distribute the assets out at the end. You've walked yourself right into some anti-avoidance rules. Common problem we see, one of the beneficiaries or more have moved to the States. Family's got money. The daughter's going to Stanford. She now lives there. I had another client. He took a big job with a U.S. company in New York. His second son was born there. They were only there for a year and a half. Now he's got a son who's a U.S. person. So, you know, those questions need to be asked. Trustees are dead. Who's the trustee? Oh, so-and-so. Well, they're not on the trust indenture. So anyway, I mean, these are things that you can really help clients with that they don't know, they don't understand. We talked about the BC Family Law Act situation. Maria, one thing I like to recommend is if you're going to do a freeze, I personally like to see a shareholders agreement in place. So the trust, mom and dad, enter into a shareholders agreement. And the shareholders agreement says you can't be a shareholder of this company unless you agree to sign this agreement. So prior to a distribution of shares out of the trust, you don't get your shares, kids, unless you sign the agreement. So what if there's a clause in there that said, I guess, the question is how do you get a spouse? I mean, you'd have to get the spouse to sign on as well. I'm thinking of some nefarious way to get spouses to sign on to agreements and say the common shares are not, or whatever the shares are not assets of the family.
So you're suggesting in that shareholders agreement, when mom and dad and the trust and the companies enter into the shareholders agreement,
it's a two-step process.
An additional requirement that before somebody become a shareholder, that they be a signatory to a family law agreement.
We're going to now distribute the shares out of the trust to the family members, and one, you have to sign the shareholders agreement before you get your share, and two, your spouse has to sign an agreement.
Well, that will depend on whether that spouse is prepared to sign on to that agreement and how badly the son or daughter wants the shares.
Yeah.
But if it's restricted to those shares, and it can be...
And there's other assets, yeah.
be sold as a benefit to the family as a whole. I think it would sell it.
So that was my last point here, shareholders agreements. I'm a big fan of family shareholder agreements. The problem is to get people signed on. Once the shares are out there amongst the family members, it's very difficult to deal with. So just a suggestion as to what you should do.
Make it part of the actual estate treaty.
Yeah. Well, and the thing, I had a situation, Mom and Dad came to me, there were 7 kids. Dad had worked all his life. He built up this nice portfolio of warehouses. They were generating a nice little piece of income. Like 2 of the kids kind of got it. The rest just wanted the money. He had a 65-year-old son who wanted to basically retire now with the estate. Of course, Mom and Dad weren't dead yet, but and I said, fine. I'm going to insist that because we're going to set this up, and there's these preferred shares. I want to have a shareholders agreement in place here. You could sit down. You should sit down and talk to your family about it. But don't spend a lot of time talking to them. Otherwise, it's just going to get really expensive. So, I said I could do this for 5 to 10. Well, 2.5 years later, $45,000 later, finally Dad came back to me and said, this is outrageous. This has cost so much in legal fees. He said, you did warn me about this. And so now I'm going to sit the kids down and tell them what we're doing because I can't do, and that, as you said, I should have listened to you at the beginning. That's the great advantage when you've got the person who's running the matriarch or patriarch. They're still alive. They can force the issue. They've been running everything in the family up to then. If you leave it when they're gone or they're disabled or they don't have mental capacity, you're hooped. So I won't bother covering the rest of this, and there we are. So thank you very much for coming. And we've got a little draw here. Maria, you're going to handle that?
Yes, Amanda. You're so kind as